Court of Appeal for Ontario. So this is the style of cause. So that would mean the people who are participants in this legal action and the names of the judges overseeing the proceeding. So the citation is Toronto, so that's the City of Toronto, versus Ontario, the Attorney General. 2018 ONCA 761. So that stands for Ontario Court of Appeal. 761. The date is September 19th, 2018. Docket number C as in cat 65861. Bracket M49615, close bracket, and bracket M49624, close bracket. This was heard before Justices Hoy, Sharpe, and Trotter. The respondents in this appeal are the City of Toronto, Rocco Achapang, and it also says City of Toronto again, so I'm a little bit confused at that. The Attorney General is putting forward this appeal, and as everyone knows, it was an appeal of the decision of Justice Belobaba, overturning the province's decision with regards to Bill 5, essentially protecting the public's rights, that they shouldn't be interrupted during the middle of an election to change the ward dynamics. And it confirmed that the 47 ward, which is what we all understood it to be, was apropos. The appeal by the province, so that would be the Honourable Doug Ford, who is now the Premier of Ontario, and the Attorney General, basically wanted to appeal Bill 5 and to ensure that their 25 ward model under the bill was applied to the City of Toronto. The reality is that this decision is not the actual appeal. It is just requesting the stay of the decision made by Justice Belobaba. So in fact, to stop the enforcement of Justice Belobaba's act, which was decision, which was immediate, but to stop that, and to in doing so, a stay is granted to prevent Justice Belobaba's decision to allow the 47 ward to be in place. So this is not the actual appeal. It's a decision based on the request for a stay of the action. So here we go. And as a reminder, it's also between the applicants who brought the initial matter, which was Rocco Achapang, and then subsequent people attached themselves to it. And that would be Chris Moyes, Ish Adoranmu, and Prabha Kholsa on her own behalf and on behalf of all members of Women Win Toronto. There's also interveners involved, and the representative or someone attached as an intervener from the Toronto District School Board, Patrick Cotter, as it says, and also the Canadian Taxpayers Federation became an intervener. So the other interveners are Jennifer Hollett, and Lily Chen, Susan Dexter, Jeffrey Kettle, and Dianush Yosefi. Here is the decision from the court dated September 18th, 2018. Although the other date said the 19th, but we'll leave it at that. And this is what the court wrote on page 3. Given the urgency of this matter, an immediate decision on this stay motion is required to ensure that the Toronto municipal elections set for October 22nd, 2018 proceed in as orderly a manner as possible. In the unusual circumstances of this case, we have decided to announce our decision without delay and with briefer reasons than otherwise might be expected for a matter of this importance. Line 2. The issue before us is whether to grant the Attorney General's motion for a stay pending an appeal to this court of the order of the Superior Court of Justice that the relevant provisions of Bill 5, the Better Local Government Act 2018, SO 2018, C11, infringe Section 2B of the Canadian Charter of Rights and Freedoms and are therefore of no force and effect. City of Toronto et al. Versus the Attorney General, 2018, ONSC 5151. So that's Ontario Superior Court, 5151. Page 4, line 3. The election period for the 2018 City of Toronto municipal elections, based on the city's bylaws providing for a 47-ward structure, began on May 1st, 2018. Bill 5, introduced on July 30th, 2018 and given royal assent on August 14th, 2018, changed the course of the elections by imposing a 25-ward structure. 3 proceedings were quickly brought to challenge the constitutionality of Bill 5, leading to the order at issue on this motion. Line 4. The constitutional challenges raised several grounds, but the basis for the application judge's decision was the argument that Bill 5 infringed Section 2B, freedom of expression rights of both the candidates and the voters. That was also the focus of the stay motion, and accordingly will be the focus for our reasons. Like the application judge, we are of the view that this was the strongest argument the respondents advanced. Line 5. The application judge found that although the province has plenary power to govern the affairs of municipalities, including municipal elections, by changing Toronto's ward structure well after candidates had been nominated and had commenced campaigning, Bill 5 violated Section 2B, freedom of expression rights of both the candidates and the voters. In his view, changing the ward structure mid-election substantially interfered with the candidate's ability to effectively communicate his or her political message to the relevant voters, and undermined an otherwise fair and equitable election process. Paragraphs 32-34. The application judge found that Bill 5 infringed municipal voters' freedom of expression rights by interfering with their right to vote. He characterized the right to vote as an expressive activity, falling within the protection of Section 2B, which, in his view, includes the right to effective representation. Paragraphs 40-47. He found that increasing the population size of the wards from an average of 61,000 to an average of 110,000 denied the voters' right to cast a vote that can result in effective representation. Paragraph 60. Page 5, line 6. The application judge rejected the Attorney General's submission that any infringement of Section 2B could be justified as a reasonable limit under Section 1 and accordingly declared parts of Bill 5 to be of no force and effect. Line 7. The Attorney General has appealed the application judge's order to this court and asked this panel to stay that order pending appeal. If granted, the effect of the stay would be to leave Bill 5 in place and require the election to proceed on the basis of a 25-ward structure. Line 8. In oral argument, counsel for the Attorney General stated that he had been instructed to advise this court that if a stay were granted, the government would not take Bill 31, the Efficient Local Government Act 2018, currently before the legislature, to a final vote at this time. Bill 31 would replace Bill 5 and include an override declaration pursuant to Section 33 of the Charter. We note that this undertaking was given, but add that it plays no part in our decision. Page 6, line 9. The three-part legal test for when an appellate court should grant a stay of a lower court decision pending an appeal is set out in the Supreme Court of Canada's decision in RJR-McDonald Incorporated versus Canada, the Attorney General, 1994. 1 SCR 311. Ordinarily, the applicant must demonstrate that there is a serious issue to be tried, that it will suffer irreparable harm if the stay is not granted, and that the balance of convenience favors a stay pending the disposition of the appeal. Line 10. The minimal serious issue to be tried component of that test assumes that the stay will operate as a temporary measure and that the rights of the parties will be finally resolved when the appeal proper is heard. However, RJR McDonald recognizes that in cases where, as a practical matter, the rights of the parties will be determined by the outcome of the stay motion, the court may give significantly more weight to the strength of the appeal. Paragraph 338. In our view, this is such a case. An immediate decision is required to permit the Toronto municipal elections to proceed on October 22nd. That decision must be rendered now, and subject to further legislative intervention, our decision will determine whether the election proceeds on the basis of 25 or 47 wards. In these circumstances, greater attention must be paid to the merits of the constitutional claim, and as contemplated by RJR McDonald, we must ask whether there is a strong likelihood that the appeal will succeed. Line 11. The application judge was understandably motivated by the fact that the timing of Bill 5 changed the rules for the election mid-campaign, which... couldn't tear to the page. I'm now on page 7, which perceived as being unfair to candidates and voters. So that reference was which he, being Justice Belobaba, perceived as being unfair to candidates and voters. However, unfairness alone does not establish a charter breach. The question for the courts is not whether Bill 5 is unfair, but whether it is unconstitutional. On that crucial question, we have concluded that there is a strong likelihood that application judge erred in law and that Attorney General's appeal to this court will succeed. Line 12. The application judge's interpretation appears to stretch both the wording and the purpose of Section 2B beyond the limits of that provision. His decision blurs the demarcation between two distinct provisions of the Charter: the protection of expressive activity in Section 2B and the Section 3 guarantee of the democratic rights of citizens to vote and be qualified for office. The Section 3 right to vote and stand for office applies only with respect to elections to the House of Commons and the provincial legislatures. Hague versus Canada, 1993, 2 SCR 995 at paragraphs 1031 and 1033. Section 3 does not apply to municipal elections and has no bearing on the issues raised in this case. Line 13. Unquestionably, Ontario's announcement of its intention to introduce Bill 5 disrupted the campaigns that were already underway. However, Bill 5 does not limit or restrict any message the candidates wish to convey to voters for the remainder of the campaign. Nor does it erase messages conveyed earlier, although it may reduce their effectiveness. While the change brought about by Bill 5 is undoubtedly frustrating for candidates who started campaigning in May 2018, we are not persuaded that their frustration amounts to a substantial interference with their freedom of expression. The candidates were and are still free to say what they want to say to the voters. The inconvenience candidates will experience because of the change from 47 to 25 words does not prevent or impede them from saying what they want to say about the issues arising in the election. Page 8, line 14. There was still considerable time from the date of Bill 5's passage until voting day. What? There was still considerable time? That doesn't make sense, but that's how it's written. It says, there was still considerable time from the date of Bill 5's passage until voting day. Election campaigns inherently involve moving targets and changing issues that require candidates to adjust as matters proceed. Under Bill 5, nominations remained open until September 14, the same deadline that applied to the previous city elections. My apologies for pausing, everyone. I'm just confused by what I'm reading out loud, and I'm reading it as I would for the first time, so you too get that information for the first time. And that is not accurate information because the deadline was July 27th. So I'm concerned about what information is written here where it says nominations remained open until September 14th, the same deadline that applied to the previous city elections. That's not correct. Anyway, it's confusing. I don't know why that's there. And I'm going to restart reading line 14 again because it just stumped me. So starting at line 14 again. There was still considerable time from the date of Bill 5's passage until voting day. Election campaigns inherently involve moving targets and changing issues that require candidates to adjust as matters proceed. Under Bill 5, nominations remained open until September 14th, the same deadline that applies to the previous city elections. There was no suggestion that permitting nominations approximately 5 weeks before the election trammeled freedom of expression in any way by putting demands upon candidates who had already entered the race and who might need to strategically refocus their campaigns in response to issues raised by new candidates. In light of the time remaining for candidates to conduct their campaigns after its enactment, we are doubtful of the claim that the disruption Bill 5 caused constituted a substantial interference with the candidate's freedom of expression. Line 15. Candidates had a reasonable expectation that they would be operating under a 47-ward platform when developing the messages for their campaigns. However, neither that platform nor that expectation was constitutionally guaranteed. The ward platform could be changed by law or by legislation. The decision of the legislature to change it during the campaign was unexpected and perhaps alarming. But candidates have no constitutionally guaranteed right to the 47-ward platform, and Bill 5 does not deprive them of their constitutional right to say whatever they want to say about civic issues. The candidate's right to freedom of expression does not carry with it the constitutional right to insist that either the city or the province provide or maintain a platform. Absent certain conditions that the application judge did not consider in this case, see Bayer, B-A-I-E-R versus Alberta, 2007, Supreme Court of Canada, Decision 31. 2007 S2 SCR 673, Hague. The application judge relied on Libman versus Quebec Attorney General 1997 3 SCR 569. But as explained in Bayer at paragraph 41, that case involved a claim to freedom from certain statutory restrictions on expressive activity, i.e. a negative entitlement. It did not involve a claim for a positive entitlement to a particular platform, as in this case. Line 16. The application judge found that because Bill 5 made the messages the candidates sought to convey less effective, it infringed their Section 2B rights. This proposition is not supported by the jurisprudence interpreting Section 2B. Bayer and Delisle, so that's D-E-L-I-S-L-E versus Canada, the Deputy Attorney General, 1999, 2 SCR 989, hold that legislation that has the effect of diminishing the effectiveness of a message but does not prevent the communication of that message does not violate Section 2B. Delisle at paragraphs 40 to 41. Baer at paragraph 48. As the minority recognized in Harper versus Canada 2004 Supreme Court of Canada Decision 33, 2004 1 SCR 827, Section 2B does protect the ability to attempt to persuade one's fellow citizens through debate and discussion. Paragraph 16. However, it does not follow that government measures which do not prevent candidates from attempting to persuade voters, but have the effect of making those attempts less effective at achieving their desired result, violate Section 2B. Line 17, page 10. With reference to the Section 2B rights of the voters, the application judge at paragraphs 40 to 61 place significant reliance on the right to effective representation, a concept recognized by the Supreme Court in Reference Re Provincial Electoral Boundaries, Saskatchewan, 1991, 2 SCR 158. We find it difficult to see how the right to effective representation, which is at the core of Section 3, is somehow embraced by Section 2B, which protects freedom of expression. Section 2B and Section 3 rights are distinct rights to be given independent meaning. Harper versus Canada, 2004, Supreme Court of Canada, 33, 2004. 1 SCR 877 at paragraph 67. Thomson Newspapers, Corporation versus Canada, Attorney General, 1998, 1 SCR 877 at paragraphs 79 to 80. Moreover, as already noted, Section 3 of the Charter has no application to municipal elections and it does not protect them. Haig at paragraph 1031. Baer at paragraphs 38-39. While rights can overlap a limit on the scope of one right. So again, I'm going to read this as it says, but it's not making sense to me. While rights can overlap and a limit on the scope of one right should not be used to narrow the scope of another right, it does not follow that doctrines pertaining to Section 3 can be imported to expand the reach of Section 2B. Line 18. Finally, the application judge's conclusion that Ontario substantially interfered with the voters' right of freedom of expression when it doubled the ward population size from a 61,000 average to an 110,000 average cannot be supported. The size of the city's electoral wards is a question of policy and choice to be determined by the legislative process subject to other provisions of the Charter, including Section 15(1). Whether wards of 61,000 or 110,000 are required to ensure effective representation is a debatable issue that cannot be determined by reference to the right to freedom of expression. Further, we share the application judge's inclination that there is no infringement of Section 15(1). 19. Line 19. Given our conclusion with respect to Section 2B, it is not necessary to consider the application judge's conclusions concerning one application of Section 1 of the Charter. Line 20. Our finding of a strong prima facie case on appeal bears upon the analysis under the second and third prongs of the RJR Macdonald framework. See RJR Macdonald at paragraph 339. We recognize that in this case, Ontario does not have a monopoly on the public interest and that the city also speaks for the public interest. However, having acceded to the argument of the respondents that the more exacting strong likelihood of success standard should be applied, and having reached the decision that the judge under appeal was probably wrongly decided, We have no doubt that the moving party would suffer irreparable harm if a stay were not granted. Sorry, but I have to ask how. How would the irreparable harm be by the province? I'm failing to see that. But that's a subjective comment I made that has nothing to do with the decisions of these three judges. So let me read it on its own without my subjective comments. Our finding of so this is again starting at line 20. Our finding of a strong prima facie case on appeal bears upon the analysis under the second and third prongs of the RJR McDonald framework. See RJR McDonald at paragraph 339. We recognize that in this case, Ontario does not have a monopoly on the public interest, and that the city also speaks for the public interest. However, having acceded to the argument of the respondents that the more exacting strong likelihood of success standard should be applied, and having reached the decision that the judgment under appeal was probably wrongly decided, we have no doubt that the moving party would suffer irreparable harm if a stay were not granted. It is not in the public interest to permit the impending election to proceed on the basis of a dubious ruling that invalidates legislation duly passed by the legislature. We do not accept the respondent's submission that because Ontario exercises its legislative authority to enact Bill 5, it does not have clean hands and should not be entitled to the equitable relief of a stay from this court. Page 12, line 21. Similarly, the balance of convenience favors granting a stay. As the Supreme Court held in Harper v. Canada, Attorney General 2000, Supreme Court of Canada Decision 57, 2002 SCR 764 at paragraph 9, courts will not lightly order the laws that Parliament or a legislature has duly enacted for the public good are inoperable in advance of complete constitutional review, which is always a complex and difficult matter. The court then stated that only in clear cases will stays preventing the enforcement of a law on the grounds of alleged unconstitutionality succeed. Given our tentative conclusion that Bill 5 does not suffer from constitutional infirmity, we have no hesitation in finding that the balance of convenience favors granting a stay. Line 22. The respondents insist upon the unfairness in the timing of Bill 5 and point to the uncertainty it has created. However, as noted by the application judge at paragraph 30, the court challenges exacerbated the difficult timeline the city clerk faces in making the necessary preparations for the election. The city clerk took steps to implement a 25 ward election upon the passage of Bill 5, and then reverted to plans for a 47 election after the application judge's order. The city clerk has indicated that she has done all she can in the circumstances to prepare for either a 25 or 47. My apologies. The city clerk took steps to implement a 25 ward election upon the passage of Bill 5, and then reverted to plans for a 47 ward election after the application judge's order. The city clerk has indicated that she has done all she can in the circumstances to prepare for either a 25 or 47 ward election, and, provided the issue is resolved promptly, an election on either basis remains possible. The respondent's claim to succeed on the balance of convenience is untenable. Line 23. For these reasons, the order of the Superior Court is stayed. Page 13, which is the last page. Line 24. The city clerk and the Attorney General asked this court to make certain ancillary orders required to conduct the election in an orderly manner. The City of Toronto indicated that it would not oppose those orders if a stay were granted. We are prepared to make the orders sought subject to any further submission as to the necessary details, and we remain seized of the matter for that purpose. So it was released September 19, 2018. The justices are Alexandra Hoy, Robert Sharpe, and Gary Trotter.